Well, welcome everyone, and thank you so much for joining me. I am Lior Samfiru, the employment lawyer, and you're here with me on this live employment law session where you get to ask questions about employment law and I get to answer them. It's as simple as that. So again, I'm Lior Samfiru, the employment lawyer with Samfiru Tumarkin LLP. You can find myself, my firm, operating in Ontario, BC, and Alberta. We have lawyers in all those provinces. We can help you with your workplace issues if you're troubled by something. Maybe something happened, maybe your boss did something, said something, maybe you want to understand if your workplace situation is legal, what to do if you're being mistreated, what to do if you lost your job, what to do if you're about to lose your job. I think you get the idea. This is the time and place where you can ask questions, get that information, get the legal knowledge that you need to navigate through this workplace issues that you may be dealing with. So again, I'm Lior Samfiru with Samfiru Tumarkin LLP, and I am live. So live session. I can sit here and talk all day, not a problem. I love talking about employment law. I'm kind of weird that way. But isn't this much more interesting, much better if you ask a question, if you tell me what you need to know, if you give me an opportunity to help you with that workplace problem? Now, before I get started answering questions, I'm going to give you some other contact information. If you want to connect with me and my team when I'm not here on social media, you want to email, you want to call, you want to fill out a form, easy. All you do is you go to employmentlawyer.ca. Look at that. The address is right there below me, employmentlawyer.ca. And when you go there, you can get the phone number, the email address, fill out a form, and we will call you if that's what you prefer. It's all there for you. And by the way, when you go to employmentlawyer.ca, you can also learn a lot more about your rights, about employment law, this very, very important topic. I say important topic because we all have jobs, right? We all work for a living. So we must, I would say, understand our legal rights, our legal options if we're dealing with a difficult workplace situation. So don't be bashful, don't be shy. I want questions. Last week, I remember I was here. I barely was able to get through all the questions. I loved it. It was fantastic. I want even more questions today. I promise I'll get through all of them. So ask, ask, ask. Let's start doing that. Let's start answering some questions that came in. You have plenty of time to ask yours. Again, I'm Lior Samfiru, the employment lawyer with Samfiru Tumarkin LLP, and let's get answering. All right, question. First one today. Thank you. And that is on YouTube from Mac420. I've worked for a doctor for over 30 years. The doctor announced retirement at the end of this year, and I would lose my job. Am I entitled to severance? I was told that my work week would change from 4 days a week to 1 day a week until the announced retirement. I have not agreed to this. What are my options? So first of all, let's forget for a second about the reduction from 4 days to 1 day. I'll come back to that. But if your employer in this situation is retiring, you're going to lose your job. Of course, you are owed severance. Someone in your situation after 30 years could easily be owed 2 years severance. You have to get that paid. Now, if you received advance notice of the termination of your employment, that notice counts towards your severance. I'll give you an example. So you're owed 24-month severance. If you got 6 months notice that you're going to be losing your job, that 6 months counts towards the 24 months, meaning at the end of the notice, you're still owed another 18 months severance in that example. So yes, you're absolutely owed severance. And by the way, this happens very often with doctors, chiropractors, dentists. If they retire and you lose your job, of course you're owed severance. Now, the other thing, though, this is maybe even more important, is they're going to reduce you for now from 4 days to 1 day. Well, guess what? You don't have to. In fact, you should not accept that. You can consider that reduction from 4 days to 1 day as a constructive dismissal. What that means is you can treat your employment as being terminated now. You don't have to wait until the retirement. If your employer is going to say from now on, you're going to go down to 1 day, that's a termination now, today, and you can get your severance now. You don't want to accept this reduction. That's a terrible thing to be doing. So that's your options. So Mac420, next step, you know what to do. You call me or you email me. You can do that through employmentlawyer.ca. Again, employmentlawyer.ca. Fantastic question. What a great way to start this session. Unbelievably good question. Thank you for that. See how easy it is? If you've just joined us, I'm Lior Samfiru, the employment lawyer, live here answering questions, telling you what you need to know about workplace rights. Very, very important. This question I just dealt with, so many important things for this person to know about. You can ask yours. I'm going to get to it right now. I'm going to continue answering questions. So if you've joined us, welcome. Ask your question about employment law. Next question on YouTube from me. Says me. What approach would you take if a crime occurred at work on camera, but the employer is covering it up? Well, if a crime occurred, the only thing you could do or should do is report it to the police and let the police deal with it. They will investigate. And, if your employer is trying to cover up a crime, that's a very serious criminal offense on its own. So your employer obviously can't and should not try to cover that. But that's a matter to the police. If a crime is committed, go to the police. Always, always, always. Thank you for that question. All right, continuing to answer questions. Let's see. Galwing has our next question. Galwing says, I'm working on a contract for the last 11 years at a siding plant. Most positions are union, but I'm not. Do non-union contract workers have normal severance entitlements? Absolutely. Well, let me give you a secret. You are not a contract employee. After 11 years, you're just an employee. What that means is, of course, you're owed severance. If at some point your employer says, that's it, you're done, we're not renewing the contract, you're out of a job, you're absolutely going to get severance the same as any other non-union employee. So, I know you've been there for 11 years. I don't know exactly the job you're doing, and I don't know your age, but you could easily be looking at a year's pay, potentially even more than that. So yes, and by the way, this happens very often where someone believes they're on a contract. Generally speaking, that's not the case. And a contract is if you're hired for a specific period of time to do a specific task, not in a situation where you're there for years, you keep signing new contracts, that's nonsense. You become a regular employee at that point. So you're absolutely a regular employee going. You're absolutely going to be owed severance. If you lose your job, whether it's next week or 10 years from now, call me right away, okay? I'll make sure you get everything that you're owed. To connect with me, very, very easy to do. Just go to employmentlawyer.ca. Again, employmentlawyer.ca. Now, I answered a question about severance for Galwing and our previous question as well. Before I continue answering questions, let me tell you or give you another important piece of information, how you can find out yourself how much severance you are owed. So you can always ask me and I'll tell you. You can call me, you can ask here, but you don't even need to do that. You can find out on your own how much severance you're owed, and it takes you a second. It's completely free. How do you do that? Well, all you do is you go to pocketemploymentlawyer.ca. Let me give that to you again. It's pocketemploymentlawyer.ca. And see that right on the screen right there. When you go to pocketemploymentlawyer.ca, you can click on the severance calculator. And that's it. You're done. You answer a few questions there, and it's going to tell you if you're owed 6 months severance, 20 months severance, 24 months severance. It's free. It's anonymous. You couldn't pay for it if you try to pay for it. It doesn't work that way. It's completely there for you. And if you want to, and only if you want to, you can even reach me and connect with me directly from that severance calculator. Okay? So pocketemploymentlawyer.ca. If you want to know if you're owed something, you go there. If you have a severance package in front of me and you want to get a sense, is this appropriate? Is it even in the right range? Again, pocketemploymentlawyer.ca. Check out the severance calculator there. And by the way, when you go to pocketemploymentlawyer.ca, other than the severance calculator, there's a bunch of other tools that you can use to find out if you're a contractor or an employee, to find out if your employer has cause to let you go, to find out if your human rights have been violated. It's all there. It's anonymous, so check it out. And it's, of course, completely free. All right. Right now, though, I am live. So I want more questions. If you've just joined me wondering who I am, why I'm here, why you're here, well, I'm employment lawyer Lior Samfiru. They call me the employment lawyer because that's what I do. And I'm here answering your questions live about workplace law, about your rights in the workplace. So if you have a question, what a great opportunity you have to ask it right now. Let me continue answering questions and show you exactly why it's so easy to get that answered. Next question, and again on YouTube from Steph. When can an employer say it's too much to provide accommodation for disability? I'm being told my request is outside of their ability, and they aren't obligated to facilitate a workplace change to help me. So very important question, and a question that I get very often. So let me answer it. When is it too much? Well, for an employer to say, gosh, that's just too hard, that's too much, it would have to be really onerous. It would have to be very expensive, very complicated, to the point that it just becomes unworkable. We call this accommodation to the point of undue hardship. What does that mean? That means that even if it's hard, your employer still has to do it. Even if it costs them money, your employer still has to do it. Now, if it becomes undue hardship, so over the top, so complicated, then of course they may not have to go quite that far. Now, obviously, without knowing more about your situation, your employer, what type of accommodation you need, I can't say if this would be considered undue hardship for your employer. So I would need that information. But here's what I can tell you. In my experience, I've been doing this for 21, 22 years. Virtually every single time when I have someone saying, hey, my employer says it's too difficult, it's not. Your employer just doesn't really want to try hard enough. And that's a human rights violation. Under human rights legislation, if your employer is able to accommodate you, they must accommodate you. Modified hours or modified duties or working from home or giving you support in the workplace, they have to do it. So if your employer won't accommodate you, very good odds that this is a human rights violation. I want you to connect with me. All right. So Steph, connect with me through employmentlawyer.ca. Again, employmentlawyer.ca. Let's get into the details and let me help you. And by the way, oftentimes when your employer says we can't accommodate you, once they hear from me, man, see how quickly, oh yeah, we can accommodate you. We're wrong. Of course we'll accommodate you. So keep that in mind. All right, thanks, by the way, for that question. And if you've just joined us, easy to get involved. I'm Lior Samfiru, the employment lawyer, and you're listening and watching my live employment law session. You can ask your question like so many people have already and get answers from me about what to do. I'm going to continue answering questions right now. You have time to ask yours, okay? All right, Carrie has our next question. Should you receive an employment... I'll do this again. I know how to read. Should you receive an updated employment agreement if you're promoted? What if you take a position in a different department within the same company? The reality is that there's no need for you to ever have to sign a new employment agreement. Now, if you're promoted, your employer can simply send you an email saying, here's your new job and your new salary. You don't need a new employment agreement. If your employer wants you to sign a new employment agreement, be very concerned. Very often, usually, in fact, in that employment agreement, there's going to be terms that are not favorable to you, terms that could limit your future severance, terms that prevent you from working somewhere, very problematic terms. So no, should you be getting a new agreement? No. If you are, let me see it. Don't sign it and then realize, holy cow, by signing this now has cost me tens of thousands of dollars in future severance, maybe hundreds of thousands of dollars. So be smart. You're better off as an employee not to ever have signed an employment agreement. A handshake deal is much better for the employee than a 10-page employment agreement. All right, so thank you for that question. Very good one. I'm going to continue answering questions. Ask yours. You got time. What are you waiting for? Ask the question. Again, I'm Lior Samfiru, the employment lawyer. All right, Tom has our next question. How long can you be laid off for on EI until you can go after severance? So Tom, here's the answer. Your employer does not have a right to put you on a temporary layoff. So if you're put on a temporary layoff, you can go after severance now on day one. So let me give you an example. If I told you that your employer reduced your pay by 50%, you'd say, well, they clearly can't do that. Of course, that would be correct. Well, what is a temporary layoff? A temporary layoff is a reduction of your pay of 100%. So if they can't reduce it by 50%, which of course they cannot, how can they reduce it by 100%? Not legal. So if you're put on a temporary layoff, you have a choice. You can choose to wait and see what happens, okay? Or you can choose to say, no, I'm going to consider this a termination. I'm going to get my severance now. So in that respect, it's up to you, the employee. You can consider this to be a constructive dismissal. Tom, if that's what you want to do, before you do anything, before you go to your employer, before you respond, before you do anything, call me. Let's have that conversation. I want to find out more about you, about your job, your history there, and then we can proceed. So hopefully that makes sense. Very common question. People assume that their employer has a right to put them on a temporary layoff. If you're a non-union employee, for most people, no, your employer does not have a right to do that. Okay, fantastic. Corey has our next question. Corey asks, does your firm offer free review and advice of severance and working notice offers? So most of our termination reviews are free. What I mean by that, if someone comes to us after they've been let go with their severance offer, etc., most of the time that is a free review. And there are situations where we have to charge a fee, and we'll let you know in advance so you can make a decision. So I can't say they're all free, but they are most of them are free. When you call us, our team will tell you yes, free, or if there's a charge, you can make a decision. That said, always, always, and forever, never accept the severance offer without talking to us. In the vast majority of cases, over 90% of the time, when someone calls us with that piece of paper, that severance offer, what they've been offered is a lot less than what they're legally owed. All right, so be smart, do the right thing. Let's talk about it. And of course, to connect with me and my team, Corey or anyone, very easy to do, employmentlawyer.ca. Again, employmentlawyer.ca. But by the way, Corey, if you're still watching, ask me right now. Tell me about your job, how long you've worked, and tell me what they've offered you. And I'll start giving you a sense right now if what they've offered you is fine or not. If you've just joined us, again, I'm Lior Samfiru, the employment lawyer with Samfiru Tumarkin LLP, and I am here live with you answering your questions. More questions have come in, but I want even more than that. Still have time, okay? So don't wait till the last minute where I may miss it. Ask your question right now. Next question from the chosen one. Is it by law to have to call all workers back who have been laid off? The company I work for is a family-owned company. Well, no, the law is that you actually can't lay them off to begin with. So again, this only applies, of course, to non-union. If your employer puts you on a layoff, that's not the law. That's illegal in most cases. So if your employer is already doing something illegal, then anything beyond that is still illegal. So chosen one, if you've been put on a temporary layoff, you can wait. Sure, you can do that. But you can also say that's a termination. I want my severance now. One of the problems with waiting beyond the obvious is if you've accepted the layoff and you waited and you went back to work, by doing that, you've potentially given the company the right to do it again and again and again. So they didn't have a right to do it the first time. But because you let them do it, you accepted it, you're okay with it, now they can do it again. It becomes an implied term of employment. Well, we did it before, you were okay with it, so we can do it again. So you could be in a situation where you work for a few months, you're off for a few months without pay. Not a good situation to be in. So if you've been put on a temporary layoff, we may just want to say, no, constructive dismissal, not okay with this. I'm going to get my severance and move on somewhere else. So chosen one, if you're in that situation, as I was saying before, don't do anything without speaking to me, all right? Contact me or my team, easy to do. Just go to employmentlawyer.ca. Again, employmentlawyer.ca to do that. Very, very easy to do. Your one-stop shop for anything employment law is employmentlawyer.ca. All right, I want some more questions, more to come right now, but if you're watching, you're learning, hopefully that you're finding what we're doing here helpful, but you may have a question of your own. Maybe you didn't have the best week last week or this week. Maybe your boss said something and you're kind of wondering, is that right? Is that legal? Should I respond? Should I do something about it? Does this even matter? Well, why not ask the question? Don't wander on your own. Oftentimes when you kind of decide on your own how to deal with the workplace issue, you may do the wrong thing and you may give up rights that you didn't even know you had. So it starts by asking a question right now. Let me help you. Let me tell you what this all means. All right. Right now, though, I'm going to answer questions. I want yours too. Next one comes from Hall. I've been working as a sales associate under a part-time contract. Last year, I applied for parental leave to end early this year. Upon my return, no shifts were assigned to me. Last month, I received an email from HR stating my contract had been terminated due to job abandonment. The letter states I've been absent from work since 2022. what can I do here? This is not true. Well, obviously something is off here. If you started parental leave last year, why would they say you haven't worked since 2022? Something is off. Either they're confusing you with someone else, or something is wrong here. So there's probably more to this situation than what you're saying. So I want you to connect with me off air. It's hard for me to respond why your employer is saying you haven't worked for 2 years if you have. So connect with me through employmentlawyer.ca. Let's have that discussion and let me find out much more about your situation. Let me help you. Thank you for that question. By the way, see how easy it is. I'm Lior Samfiru, the employment lawyer. I'm live here. And of course, to connect with me when I'm not here, by phone, by email, no problem. Easy to do. Just go to employmentlawyer.ca. All the info that you need to connect with me is right there, and it's right here on the screen. So check it out. Fantastic. Let's continue. More questions coming in. You got some time. You got 10 minutes or so. Plenty of time. Ask questions. Dennis Goff has our next question. I was injured at work. I'm off on WorkSafe. After surgery, I'm unable to return to original job. Was offered what myself and WorkSafe considered unreasonable accommodation, and then was terminated without notice. They say no severance due to disability. Wow. Okay. So your employer must accommodate you if they can. Okay. So if they didn't accommodate you, if they didn't provide you reasonable accommodation, but they could have if they wanted to, human rights violation. Okay. And if they let you go, another human rights violation, not to mention a wrongful dismissal. The only time what they did would have been legal is if they tried to accommodate you, it was not possible, and your limitations would have stayed like this forever, and they never would have been able to accommodate you. So if it's a situation where you need certain accommodation forever and they'll never be able to provide that accommodation, then they can terminate for what we call frustration of contract and not have to pay you. But they would have to show that they can't accommodate, which they probably cannot do. And number two, they'd have to show that those restrictions that you have will be permanent, which they probably also cannot do. So we're looking here, Dennis, likely at a human rights violation, wrongful dismissal. You got to call me, okay? Don't let them get away with this. So Dennis, to connect with me today, don't even wait on this. Easy, employmentlawyer.ca. Got your back right here, employmentlawyer.ca. By the way, if you have a follow-up question, still here. Ask it, no problem. All right, let's see. Next question comes from Rishi. Laid off temporarily, 3 months. Okay, there's no real question there, so you haven't asked a question. But ultimately, as I was saying earlier, Rishi, your employer does not have a right for non-unionized employees, in most cases, to put you on a temporary layoff. So if you're on a temporary layoff now, you may be able to consider that a termination. Right? And Rishi just did a follow-up. Laid off with benefits, been 13 weeks already. Contract mentions temporary layoff, okay. 2+ years, senior level, niche position, firm posted jobs since in the same team. So I would want to see your employment agreement. If your employment agreement specifically gives them the power to lay you off, then they can lay you off, and it could be as long as 8 months. Okay, so not a good situation. But I want to see your employment agreement. If your employment agreement does give them that power, it's a problem. If it doesn't, or if we have a way around it, you can consider that potentially as a termination right now. So I'd have to see your employment agreement, Rishi. You want to connect with me as soon as possible through employmentlawyer.ca, okay? This all comes down to that employment agreement. That's really it. Now, if your employment agreement does allow them to lay you off temporarily, if they don't call you back, then at that point it becomes a termination. But hopefully you don't have to wait that long. Hopefully we can find out right now. Again, that comes down to your employment agreement. All right, let's see. Let's get some more questions. You still have time to kind of get a couple questions asked, to get me to answer them, to get some help, to get some advice. So take advantage. Again, I'm Lior Samfiru, the employment lawyer. Next question from CPC. I am a truck driver. Last week, I was wrongfully dismissed by my employer. My employer did not pay me and screamed and called me names in front of all the other drivers. Lovely. There were no termination papers. He refused to pay me, saying that my pay was to be docked to pay for the damage on the trucks. My employer has insurance on the trucks. Can I sue my employer for wrongful dismissal? Absolutely, you can. And obviously, I want to know what happened with the trucks, whose fault was it, how many times, well, how bad was the damage, et cetera, et cetera. So I want to understand all that. But it's going to be very difficult to let you go without severance unless you essentially were doing something deliberately. So yes, let's talk about that. Let me get your contact me and get that contact information through employmentlawyer.ca, and let me get you that severance. Yes, remember the rule. The only time a company can let someone go and not pay them severance is if the employee did something awful, something terrible. And if the employee did that and the employer can prove it, maybe then the company is allowed to just let the person go and not pay them severance. But here's the thing. In my experience, again, many years of doing this, in the vast majority of cases when a company says, oh, no, we don't have to pay you severance, that's wrong. That's a wrongful dismissal. Even if you did something wrong, that does not mean that it rises to the level of being let go without any severance. So let's have that discussion. Connect with me through employmentlawyer.ca. Thank you for that. Rishi has a follow-up comment here. It says the language is vague in the contract. Well, Rishi, for you to try to interpret the contract, it's not a good idea. That's why I said you got to contact me. Let me do what I do. I can tell you in 10 seconds if it does allow them to lay you off properly or if it doesn't, if there's ways around it. So again, connect with me through employmentlawyer.ca and let's do that. All right, let's see if we can get to another question. This one is from Lucy. I work for a Canadian office owned by a U.S. company. All the staff have been notified that the Ontario division will be shut down. Some staff will stay on, and others have been told that they are given 2 months to look for another job. Are they able to receive a package? Well, sure, absolutely. To see how much you're owed, anyone affected that's owed, go to pocketemploymentlawyer.ca and use the severance calculator. Again, pocketemploymentlawyer.ca and use the severance calculator. If you lose your job, you are owed severance. It's as simple as that. Now, if you receive advance notice of your termination date, that notice will count towards your severance. But yes, of course, you're owed severance. So Lucy, you, your colleagues, easy to do. Employmentlawyer.ca, very easy. Rishi says, I've tried reaching your team, but was not told which lawyer would work with me. Sorry, that's not how it works. If you call us, we will schedule an appointment for you for a lawyer, unless, of course, you're part of a union. There's no such thing as we don't tell you. Connect with us, again, employmentlawyer.ca. So maybe there was a misunderstanding. If you want, if you're in a situation we need a consultation, to connect with us, easy, employmentlawyer.ca, and we'll do that consultation. All right, let's see. Maybe last question. Brandon. I am on a temporary layoff. I have been offered a recall to work. My job title has changed, something I don't see as a benefit to my career, but I've received a pay increase. I want to refuse the offer, but I'm afraid I'll lose severance eligibility. How can I find out if my employer has proposes enough of a change for me to initiate constructive dismissal? So here's the thing, Brandon. It's probably not enough of a change, but forget about that. The constructive dismissal was the temporary layoff. So you can take the position that when they put you on a temporary layoff a month, 2 months, 6 months ago, whatever that was was the constructive dismissal. Forget about this new role. It's that you've been already constructively dismissed, so you're now already owed severance. So that's the key here. The constructive dismissal, as I've been saying, happens when you're put on a temporary layoff. For most people, your employer does not have a right to reduce your pay by 100%. That's what a temporary layoff is, right? So if you've been put on a temporary layoff, Brandon, that constructive dismissal has happened. So connect with me so we can have that discussion so I can better understand your situation and assess how much you are owed. Very easy to do that, Brandon. Employmentlawyer.ca. Again, employmentlawyer.ca. Fantastic, guys. This is the time that we have for today. I'm so grateful to have been here, to have had the opportunity to get so many questions, to answer them, and hopefully help you better understand your legal rights. Guys, I'm not going anywhere. My team's not going anywhere. You can still reach us now if you want through employmentlawyer.ca. All the contact and information that you need is right there. I'll be back next week, same time, same place, but don't wait until then. Let's talk later today. Let's talk tomorrow. Let's talk the day after. Easy to do. Again, employmentlawyer.ca. I'm Lior Samfiru, the employment lawyer with Samfiru to Markin LLP. You were listening to my live employment law session. Thank you so much for joining me. Take care of yourself, and we'll talk soon.